All right. Hi, everyone. Thank you so much for being here. So, the topic of today's webinar is the Supreme Court's decision in the case of United States versus Skrmetti from this past Wednesday. And our panelists today will be in alphabetical order: Claire Abernathy, Elizabeth Chesak, myself, Kara Dansky, and Prisha Mosley. So before we get too much underway here, and also as participants trickle in, I just wanted to draw your attention to the upcoming WDI USA convention. So I'll pop that link in the chat, but it will be September 19th through the 21st in Indianapolis, Indiana this year. So it's 3 incredible days of learning and networking and just meeting amazing women. It's one of my favorite times of year. What else was I going to say? Oh, yes. And all 4 of the speakers today will be speakers at that convention. So Kara will give a talk on Friday evening about where we are in the movement to protect women's sex-based rights. And then I will be facilitating a panel that Claire, Prisha, and 2 other detransitioners will appear on called Detransition What's Next. So as I said, I'll pop that link in the chat. But I encourage you all to buy a ticket. It is women only for what it's worth, but if you're a guy in this webinar, feel free to tell the women in your life about it. Alrighty. Sorry, let me just move over to my notes. So as I mentioned, today's webinar is about the Supreme Court's Wednesday decision in the case of United States versus Skrmetti. So in a 6-3 split, the United States Supreme Court ruled that states can ban medical procedures aimed at disguising the sex of minors. And WDI USA had filed an amicus curiae brief in the case, another link that I'll post in the chat. So Kara's here to discuss the case, our brief, and the implications of the Supreme Court decision, and she'll be joined by Claire, Prisha, and myself. We also put out a press release the other day, which I will link in the chat. Sorry, hot day here. So I will introduce the panelists next. So I'm just going to go in alphabetical order because that's how I have you all listed. Claire Abernathy is a 20-year-old detransitioner and advocate from Texas. At 12 years old, following a traumatic sexual assault, 14, she was prescribed cross-sex hormones and underwent a double mastectomy. At 16, she made the decision to detransition and reclaim her life. Through public speaking, writing, and advocacy work, she shares her story to inform parents, policymakers, and healthcare providers about the lasting consequences of medical transitions in vulnerable youth. Kara Dansky is a lawyer, writer, and founder of the Substack newsletter The Turf Report, as well as the Democratic Women's Declaration. She has published 2 books, The Reckoning, How the Democrats and the Left Betrayed Women and Girls, and The Abolition of Sex, How the Transgender Agenda Harms Women. She served as president and member of the board of directors of WDI USA from 2021 to 2024, and as a member of the board of directors of the Women's Liberation Front from 2016 to 2020. She also serves on the editorial board of the academic journal Dignity, a journal of analysis of exploitation and violence. Before turfing herself out of a career, she worked to reform the U.S. criminal justice system, including as senior counsel on criminal justice policy at the ACLU from 2012 to 2014. She has a JD from the University of Pennsylvania Carey Law School and a BA from Johns Hopkins University. So I'm Elizabeth Chesak. I discovered radical feminism in 2019 while deprogramming from years spent in the gender identity cult. I'm especially interested in connecting older and younger feminists so that the generations may benefit from each other's knowledge, skills, and ideas. I first joined WDI USA as chief of staff, and I currently serve as its president and facilitate our Desisted and Detransitioned Women's Caucus. Prisha Mosley is a 27-year-old mother and detransitioner who advocates so that no one else is harmed the way she was. She has testified in state legislatures and worked with lawmakers to protect others. So thank you all so much for being here. So Carol, would you like to begin with a description of United States versus Skrmetti and our brief in it?
Sure. Thanks so much to WDI USA for having this important discussion about US versus Skrmetti. This is an important win for women and children, and I'm honored to be here with all three of these other fantastic panelists. So in this case, the state of Tennessee enacted a law that protects minors from harmful drugs, such as puberty blockers and opposite-sex hormones. As we all know, it is well established that such drugs cause long-term harm, such as sterility, disease, and the inability to develop sexual function as an adult. And yet, a group of minors and their parents, represented by the ACLU, where, as Elizabeth said, I once worked, sued the state, demanding access to these harmful drugs. They argued that the Tennessee law violates their right to equal protection of the law under the 14th Amendment to the Constitution. And the case made its way all the way up to the Supreme Court. This past Wednesday, the Supreme Court ruled that the Tennessee law is constitutional. On the whole, that's a great thing, and I'm happy about the outcome. However, the court did not go as far as WDI USA wanted it to go. At the heart of the matter is the question of whether claims about so-called gender identity discrimination brought under the Equal Protection Clause get subjected to what's called heightened scrutiny. If the phrase transgender people qualifies as what's called a quasi-suspect class, such claims of discrimination would get heightened scrutiny. And it would be harder to show that a law like Tennessee's law is constitutional. WDI USA had filed a friend of the court brief, and in our brief, we argued that transgender cannot be protected legally because it has no coherent meaning, is not immutable, and does not describe a politically powerless group. Second, that children have an international human right to grow into adulthood and to be protected from the harms that result from blocking puberty, administering opposite-sex hormones, and/or performing surgeries to disguise sex. And three, that sex is grounded in material reality, whereas gender is regressive sexist stereotypes. I'm happy to say that we used the ACLU's own definition of transgender against it in the brief. According to the ACLU, the word transgender means the following, and I'm quoting them directly. Quote, a broad range of identities and experiences that fall outside of the traditional understanding of gender. The ACLU continues, quote, some of those identities and experiences include people whose gender identity is different from the sex they were assigned at birth, people who transition from living as one gender to another or wish to do so, often described by the clinical term transsexual, people who cross-dress part of the time, and people who identify outside the traditional gender binary, meaning they identify as something other than male or female. Some transgender people describe themselves as gender variant or gender non-conforming. Not everyone who doesn't conform to gender stereotypes, however, identifies as transgender. Many people don't conform to gender stereotypes, but also continue to identify with the gender assigned to them at birth, like butch women or femme men. Now, we said in the brief that it would defy reason to establish a quasi-suspect class of such people for equal protection purposes, and that the Supreme Court ought not want to be the court that establishes such a classification for a group of people that, at least according to the ACLU, includes part-time cross-dressers. So, this is how the majority opinion, authored by Chief Justice Roberts, begins. An estimated 1.6 million Americans over the age of 13 identify as transgender, meaning that their gender identity does not align with their biological sex. Some transgender individuals suffer from gender dysphoria, a medical condition characterized by persistent clinically significant distress resulting from an incongruence between gender identity and biological sex. Left untreated, gender dysphoria may result in severe physical and psychological harms. So this is the Chief Justice of the United States Supreme Court beginning this opinion right out of the gate with language that is used by the opponents of the material reality of sex. I'm disappointed that Chief Justice Roberts uses this language and that a majority of Supreme Court justices begins with these premises. The majority decides that the Tennessee law is not a sex-based classification and that it does not discriminate based on transgender status. It goes on to opine that its 2020 decision in Bostock did not impact its analysis in this case. In Bostock, the court had ruled that discriminating against someone on the basis of transgender status in employment constitutes unlawful sex discrimination under Title VII of the Civil Rights Act. The Biden administration essentially took that decision and made a complete mess of everything all over the country. Bostock was authored by Justice Gorsuch, who never told us anything about what the phrase transgender status means. I'm disappointed by the majority opinion for a few additional reasons that go beyond language. First, I wish the court had ruled explicitly that trans is not a protected category for equal protection purposes. Second, I'm extremely frustrated with Justice Gorsuch for not fixing the mess he created in Bostock. A lot of people thought this case was a great opportunity to clean up that mess, and the court didn't take it. Now, the majority opinion does make some important observations about sex stereotypes and states that the law does not unlawfully force kids into sex stereotypes. This is ultimately a clear win. Most of us wanted the court to affirm the Sixth Circuit's 2023 decision upholding the Tennessee law, and it did. But it did not do what WDI USA wanted to do, which is rule that transgender is not a protected category in the law, or in legal terms, a quasi-suspect class, and clean up the mess it made in Bostock. So that brings me to the concurring opinions, which are very important, but maybe I'll stop here and go to the other panelists, and then we can come back to the concurring opinions later. Is that good?
Sure, that sounds good. Thank you so much, Kara. Claire, do you want to go first?
Hi, sure. As Elizabeth said, I'm Claire. I'm an advocate from Texas, and as someone who transitioned as a minor who underwent these interventions, I think that affirming states' rights to protect children from these kind of interventions is so important. And I would agree that I agree with the court's decision that doing so is not discrimination based on a protected category or based on sex. It's saying a specific diagnosis isn't a appropriate cause for a treatment, not a certain sex. It was a reach to begin with. It was a losing case from the start. And it makes me sad to see what the ACLU has become. They were fighting for sex offenders not to be chemically castrated just a decade ago, and now they're fighting for children to be chemically castrated, ignoring the side effects of why they said it shouldn't happen to the sex offenders. I didn't have a ton prepared to say today, but I just wanted to thank Elizabeth for hosting this webinar and share my excitement for the conference in September. And I'll pass it on to Prisha.
Thanks, Prisha.
Oh yeah, my name is Prisha. I'm a detransitioner. I'm also a mother. I started my transition as a minor and continued on for several years under the misguided belief that I was actually having a sex change and that making alterations to my body could cure mental illness. I really believed my doctors when they told me that. And I also believed that these medical interventions were going, like, I believed that I had a medical condition and that these medical interventions were going to cure me of the condition that would lead to my ultimate suicide. All of my other mental illnesses were brushed to the side, and the things I was going through were not treated ethically, and my suicidality was attributed to being born in the wrong body. But Kate Strangio from the ACLU actually did testify under oath that there's no reduction in the suicide rate when children are given exogenous hormones and surgery to disguise their sex, which is a great way to put it, by the way, disguising their sex, because a sex change doesn't happen. I can't say I am surprised by this ruling myself. In fact, it came a little bit early. They had until July to give the ruling, I think, and they gave it in June. Happy Pride Month, everyone. But it's an amazing ruling, and it's so important. Like, I can't overstate the importance, because if this had gone the other way, in 26 states, the work that myself and Claire and other detransitioners and whistleblowers and parents have been doing to try to advocate for these laws would be worthless. These laws would not be lawful. But instead, this 6 out of the 9 justices voted for the laws are lawful, and they can stay in place, and that Tennessee and other states have the right to follow through on their duty to protect children from doctors who are defrauding and harming them. So thank you.
Thanks. So my commentary is just that I am happy that states can now ban medical procedures aimed at disguising the sex of minors. Article 9 of the Declaration on Women's Sex-Based Rights, which is our founding document, reaffirms the need for the protection of the rights of the child, including the right to grow up free from harmful medical interventions, such as so-called puberty blockers, cross-sex hormones, and surgeries. So in my work with the Desisted and Detransitioned Women's Caucus, I'm in contact with many women who now deeply regret the medical interventions they underwent and wish someone had protected them as children. So Wednesday's ruling was a step towards ensuring that children grow up free from these harmful procedures. And I just want to take this opportunity to say that no matter what the outcome would have been, we would have continued on our fight to protect the rights of children and to protect the rights of women and girls. So, I'm very happy that the ruling was in our favor, but either way, that would not dissuade us from the fight. Kara, do you want to pop in with the dissenting opinions?
Sure. So I want to talk about the concurrences first, but the dissenting opinion was authored by Justice Sotomayor, joined in full by Justice Jackson, and joined in part by Justice Kagan. And I'll just say there is a question in the chat about why Justice Kagan voted this way. I am not at all surprised to see that Justice Kagan voted this way. But one thing that is very interesting about Justice Kagan is that Justice Sotomayor and Jackson both decided that the law was subjected to heightened scrutiny, and also that the law passed heightened scrutiny. So Sotomayor and Jackson both would have would have struck down the Tennessee law. Justice Kagan agreed with Sotomayor's analysis that the law violates the Equal Protection Clause, but she disagreed on what to do about that. So in this case, there was a little bit of a dispute between the United States government and the ACLU. The ACLU was asking the court to do what Justices Sotomayor and Jackson would have done. the United States government took a much more cautious approach, which was ask the Supreme Court to find that heightened scrutiny applies and then send it back to the Court of Appeals for an analysis of that question. And that's what Justice Kagan voted for. So Kagan is actually somewhat, she goes a little bit less far than Sotomayor and Jackson go. So I'll say a little bit more about Sotomayor's dissent in a minute. But first, I will say that the first concurrence is by Justice Thomas. And I should say, this is difficult for so many of us who strongly supported Anita Hill when she was testifying against Justice Thomas's nomination. And it's just devastating to have to really be very happy about an opinion issued by Justice Thomas. But anyway, Justice Thomas does a deep dive into the drugs at issue here. He notes the important point that although puberty blockers have been FDA approved for treatment of precocious puberty, they have not been approved to address so-called gender dysphoria. So any use of puberty blockers to address so-called gender dysphoria is off-label. That's not illegal. There's nothing wrong with prescribing a drug for an off-label use, but it's just important and noteworthy. It means the FDA has not thoroughly investigated puberty blockers for this purpose. Justice Thomas does not hold back in his discussion of the very serious harms that can come from their administration, that can come from the administration of either type of drug. He discusses the Cass review, which I think is great, and exposes WPATH for promoting the idea of a unique gender identity. Later in his concurring opinion, Justice Thomas really unloads on WPATH, saying that there are good reasons for thinking that it is driven by ideology rather than by science, which we all know. Justice Thomas does not himself say that trans is not a quasi-suspect class for equal protection purposes, which is interesting because Justice Thomas joined with Justice Barrett, who does say that trans is not a quasi-suspect class for equal protection purposes. In my view, Justice Barrett's concurring opinion is a thing of beauty, although she uses the phrase transgender status without definition, which is frustrating. Her concurring opinion reads with refreshing clarity, and it's very short. She quotes both WPATH and the American Psychological Association to underscore the fact that trans is not a discrete or coherent category. Then, in a moment of deliciousness, Justice Barrett takes a shot at Chase, or Kate, as Prisha said, Strangio, when she says, quote, underscoring the point, plaintiff's counsel acknowledged at oral argument that there are people who fall within the transgender identity who may not fit into a binary identity. She's quoting Chase directly here in ruling against Chase. So that's great. Barrett goes on to explain that so-called transgender people have no history of being discriminated against under the law. In doing so, she helpfully explains that when it decided that sex is a protected category, it explained that women had, in fact, been historically discriminated against in the law. That was in 1971, when the Supreme Court first ruled that women deserve protection on the basis of sex under the Constitution. Barrett does not address the question whether so-called transgender people are a politically powerless group, which the court below, the Court of Appeals, had ruled that the phrase transgender people does not describe a politically powerless group, which of course, as we know, is true. But Barrett, again, does emphasize that so-called transgender people have not suffered a history of discrimination in the law. So that brings me to Justice Alito's concurrence, which I also very much appreciate, even though he too uses the phrase transgender persons uncritically. I honestly don't know what's going on with all these conservative justices just going along with the pretense that the phrase transgender person makes any kind of coherent sense. Anyway, Justice Alito agrees with the majority that Tennessee's law does not constitute unlawful sex discrimination, with Thomas that Bostock has nothing to do with this case, and with Barrett, that trans is not a protected category or a quasi-suspect class. He disagrees with the majority on whether the Tennessee law classifies based on transgender status. He says that he would assume for the sake of argument that the law classifies based on transgender status, but that he would nevertheless sustain the law because such a classification does not warrant heightened scrutiny. He gets into a bit of an interesting discussion about how the court shifted from referring to discrimination based on sex to discrimination based on gender. And he notes that when the court made that shift, it was simply adopting a similar shift that was happening in general usage, and that by gender, it never meant anything other than a synonym for sex. He's right. And although I wish the court had never made that linguistic shift, I think it's pretty obvious that when in the 1980s and 1990s, the Supreme Court began talking about gender as a synonym for sex, it did not mean that it was arguing that people should receive special legal protection for their made-up gender identities. He then goes into a long discussion about what it means for a law to classify based on sex, which is that a law distinguishes between male and female. So that's very helpful. I'm not entirely sure what to make of Justice Alito's concurrence. He appears to concede that the Tennessee law discriminates against transgender persons, and he appears to at least think he knows what he means by the phrase transgender persons, but he never tells us what he means. In any event, Justice Alito agrees that trans is not a quasi-suspect classification, so that's good. So that brings me finally to Justice Sotomayor's dissent, which again, Justice Jackson joins in full and Justice Kagan joins in part. Sotomayor has decided that the Tennessee law does not constitute sex discrimination or gender identity discrimination. It does constitute, excuse me. Sotomayor has decided that the Tennessee law does constitute both sex discrimination and gender identity discrimination, and that is therefore to be subject to heightened scrutiny. Her opinion begins with several paragraphs that use all sorts of language with which many of us would disagree. And she begins the opening paragraphs by saying, "In sadness, I dissent." So I just want to note that this is a completely ridiculous thing for her to say, that her dissent is in sadness. This is not language that should be used by a sitting Supreme Court justice. So here's my issue. Every single member of the United States Supreme Court appears to think that trans is real in one way or another. Thomas, Barrett, and Alito, all of whom think that trans is not a category worthy of protection under the Equal Protection Clause, which is good, still throw around phrases like transgender kids, transgender people, and transgender status. This is a legal win. The Tennessee law stands, and it states that states can protect children from the harms of puberty blockers and opposite sex hormones. We haven't gotten into surgery, and I can explain why this case doesn't touch on surgery if you'd like. So this is great. However, I really wanted the court to come right out and say that trans is not a protected category and that sex is grounded in material reality. Maybe I was being naive. I don't know. And again, the court did not clean up the mess it made in Bostock, so I'm annoyed about that. However, the fact that sex is real and material does run throughout the majority opinion and the concurrences, and even the dissent for that matter, even though none of those opinions says it flat out. On the whole, this is a win, and I'm happy to take it. I just want to end by saying that after the decision, UC Berkeley published a blog post about what its so-called experts think about the decision. And I was going to post it in the chat, but I can't because for whatever reason that Elizabeth was explaining, panelists don't seem to have the ability to post in the chat, and I don't know why. That's okay. The Berkeley blog post about experts includes an analysis by Judith Butler. I have not read Judith Butler's so-called expert analysis because I don't care what Judith Butler thinks about anything. However, some of you might, and I want to make this available in case it's useful. I might send this to you, Elizabeth, via direct message, and then you can post in the chat.
Yes, please do.
Okay.
And we do have someone who would like you to talk about why this case doesn't touch on surgery.
Okay. So the Tennessee law prohibits puberty blockers, opposite sex hormones, and surgeries. This case didn't touch on surgeries because the minors in question aren't seeking surgeries. The minors in question only want access to puberty blockers and opposite sex hormones. And so at some point, I believe before the court decided that these minors and their parents don't have standing to address the question of surgeries because they weren't asking for it. So the whole question of surgeries has dropped out. Now, having said that, I am confident that if the question of so-called gender surgeries for minors were to go before the court, they would rule in the exact same way that they did here. So it's not as though, I don't think that this Supreme Court thinks that so-called gender surgeries are somehow protected. It's just to say that this particular case touched on hormones, but not surgeries.
Thanks. And an attendee by the fantastic name of Kate Zephyrhawk actually shared the link to the Berkeley blog post. All right, let me scroll up where our questions are coming in. What upcoming cases related to gender identity ideology can we expect the court to take up? Or would you like the court to take up?
Okay, so the court is currently considering at least one case. There's a case called Mahamud, I think, versus Abernathy. I'm not sure. But this is a case in which some parents in Maryland have sued their school district for essentially indoctrinating their children in so-called gender identity. So that case could come out at any time. There's another case called Childs, and I don't remember off the top of my head whether the court has taken that up and is currently considering it, or if the court is currently considering whether to take it up. But this is a case in which a therapist in Colorado essentially wants to be able to talk minors and adults out of their thinking that they have a gender identity that's opposite to their sex. She wants to be able to provide appropriate counseling to help people embrace themselves as the sex that they are, and Colorado prohibits that. So that case is pending. I will also just say this particular therapist also wants to be able to talk people out of sexual orientation, which I find to be extremely problematic. There are two cases where we're waiting and have been waiting for a very long time for the court to decide whether to take them. And one of them is BPJ, and the other one is Hecox versus Little. These are both sports cases. BPJ comes out of West Virginia. Hecox v. Little comes out of Idaho. Both states have laws on the books that protect female-only sports. And in both cases, male athletes have sued those states to be able to participate in female-only sports. And in both cases, the male athletes are represented by the ACLU, unsurprisingly. So those are ones that come to mind most immediately about what we might be able to see before the Supreme Court soon.
Right. Ariane asks, due to this decision, will it be easier to convince states to pass laws forcing insurance companies to cover detransition medical procedures?
I would actually think that Claire or Prisha might be in a better position to answer that, because I have not been super active at the state level in advocating for such laws. Of course, I support them, but I have not been active in that area.
Yeah, please do feel free to jump in, all panelists.
Hey, so yeah, there's only one state that has passed a bill on that so far. It's passed in the House and the Senate and all of that, and that is in Texas. I can't remember the bill number right now, but that bill basically said that if the insurance you carry covers transition for anyone, they must also cover, and or ever has covered transition for anyone, they must also cover detransition care for you. So it has insurance companies covering the back end of transition care, which was fair. There were a lot of hearings on that one, and it was hard to get through, but we testified a lot that we were hoping that this would set a precedent for other states to adopt this law. And that does happen a lot when Texas does the laws or something. Like, people do copy Texas a lot. So, I mean, I feel sort of hopeful about that. I think similar bills have been filed in other states but haven't passed. Like, North Carolina had a detransitioner Bill of Rights filed, and so did Michigan, but they either haven't been heard or haven't passed and stuff like that. I know that the legislative session as a whole is winding down right now because it's summer, but hopefully after, like, I don't know, this decision is a little settled and things come back in the fall, like, that can be on the table, is just what I think.
Mhm.
Um,
And our state legislative advocacy. Oh, sorry. I was just going to say, our state legislative advocacy team coordinator Lauren says there are pending bills in a number of states that would require coverage of these procedures. I believe we submitted written testimony for the Texas bill. Sorry, Claire.
no worries. The bill in Texas was HB 778, and similar laws were proposed in Oregon and Arizona, and they were both vetoed. They had made it through the Houses and Senate, but were vetoed by the various governors. I don't know why this decision would make it easier to pass those bills, but I would be hopeful that it would, because such bills set a really important precedent. The one in Texas is based around the Women's Health and Cancer Rights Act, which protects breast reconstruction access for women who have had cancer or prophylactic mastectomies. And I think it sets a really important precedent, and it bases the advocacy around women's rights, in a way. And I think it's important to keep the two movements close, in my view.
Can I actually add something building on what Prisha and Claire said? So this gets to the relevance of the concurring opinions and why I wanted to share them. Concurring opinions are not controlling, and it's only the majority's opinion here that's controlling. However, Justice Thomas did highlight the experiences of detransitioners in his concurring opinion. And again, he did a deep dive into the harms these drugs cause, and blasting WPATH in particular. And even though that opinion is not controlling anywhere, the language used in that opinion can absolutely be used in advocacy to get more of these bills passed. And I hope that whoever is pushing for these bills to get passed at the state level do use the language that Justice Thomas used in his concurrence, because it would be very powerful. So I do think that that language can be used as advocacy. Whether it will be helpful in getting bills passed is hard to say.
Thanks. We have similar questions from attendees Mark and Maggie, who want to know why you think Justices Kagan and Sotomayor voted against or dissented.
So Justice Sotomayor and Justice Jackson, who quite famously was unable to tell us what a woman is during her confirmation hearings, they are totally captured. They are just completely, absolutely 1000% captured by this. Justice Kagan, again, I don't want to read too much into the fact that Justice Kagan didn't go as far as Justices Sotomayor and Jackson went. I do just find it mildly interesting that Kagan would have sent it back to the Court of Appeals instead of upholding Tennessee's law. I'm sorry, Justice Kagan would have sent it back to the Court of Appeals instead of voting to dismiss Tennessee's law, which Sotomayor and Jackson both would have done. Claire saying they seem like true believers, not just grifters, and I agree.
Mm-hmm. You know, that leads me to a question I have for all of the panelists. So I don't know to what extent Any of any of you have true believers in gender identity ideology in your life? How have they reacted to the news of this case?
The true believers that I have in my life are well familiar with my stance on the matter, so don't generally bring stuff like that up to me. But I know that a lot of people are very upset, and that those emotions are very real. I think many of us on this panel can relate to that feeling. A lot of us were trans-identified during the first Trump election, and that's a real fear. And it is sad that they feel that way, but I hope that they would find a more reality grounded place to be.
Mm-hmm. Absolutely. All right. Heather wanted to know if this decision sets a precedent for other states to enact their own bans.
Sure, absolutely. And I hope they do. I'm not convinced that similar bans will be passed in a single blue state anytime in the near future. But yeah, absolutely. This can be a basis for states to pass similar ones. I mean, similar laws are in effect in, I want to say, a total of 24 states. I don't know if Prisha or Claire has more information than that, but it's at least in the mid to upper 20s, which have similar bans. And I think everyone thinks that this outcome will be sufficient for those states to keep their bans in place. Claire's saying in a message that she thinks it's 26.
All right. Do you have any predictions about the outcomes of currently pending lawsuits, such as the one against Joanna Olson Kennedy?
I don't know if that's to me, but
It was not addressed to anyone in particular.
So I don't have any opinions on the outcome of that case, mainly because I don't know anything about medical malpractice or consumer fraud or any of the other very creative and wonderful claims that have been brought against Olson Kennedy and others. My work is mostly focused on constitutional law, in particular women's rights. And so I'm very hesitant to weigh in about areas of law of which I'm pretty much completely ignorant.
I think that Joanna Olson Kennedy does not have a leg to stand on in this case because primarily what the claim is that she didn't properly inform Mrs. Breen, and she's on video all over the internet saying the things that it's alleged that she said about, like, if you want breasts later, you can go and get them, and that puberty blockers are reversible. And so I'm very confident that that lawsuit is not going to go well for her. But the Layla Jane lawsuit in California, I felt similarly confident about, and it got dismissed. So it's uncertain, I guess.
I did find it encouraging that last week, the quote-unquote Gender Identity Center in LA that Olson Kennedy is the director of was shut down. We have a question from Judy. Will the decision possibly make insurance companies not pay for so-called transitioning surgeries? So I guess this is I guess your question is, in the absence of legislation requiring them to, will they take that upon themselves to do so?
I don't know. As Elizabeth said, the Children's Hospital of LA appears to be voluntarily closing because of the threat of the withdrawal of federal funding. Someone asked me recently, is this decision even necessary, given that Trump has threatened the funding of federally funded entities that continue to administer these harmful practices? And my answer is absolutely yes, because at a minimum, because Trump can't touch private entities that perform these harmful services. So at the very least, this ruling is very important so that private entities in Tennessee and the other states that have similar bans in place also can't do it. You know, the ones that don't receive federal funding. But it's also, I mean, the ruling is also important for what the concurrences say, right? I mean, this case has implications beyond the specific factual issues. Because the ACLU brought it as an equal protection case, this case and similar cases have major implications for the sex-based rights of women and girls. So, you know, this case was an important case for a lot of reasons.
I also wanted to say that just because the Children's Hospital said that they are stopping these procedures doesn't mean it's true. A hospital in Texas said that they were stopping the procedures in response to Trump's executive order so that they wouldn't lose funding. And then a whistleblower came out and said that they were continuing them, just doing them fraudulently, like hiding the procedures in the billing codes, like saying endocrine disorder unspecified and stuff, or changing a patient's sex in the record so that it looks like you're not administering testosterone to a female, and etc. So that's another reason this ruling is important, because the doctors just essentially get away with that, and they might lose funding if they're caught for that. But if these laws in place that make it, you know, criminal to do this, or, you know, help detransitioners to help there be some sort of accountability, well, it does just that. It creates accountability.
I think this is a question for Kara from Tina. There are plans in the work to gut the Civil Rights Act. Disparate impact will most certainly go. Most Americans oppose it, and Congress can do away with that without court intervention. What impact would the overturning of the Civil Rights Act have on this ruling, if any?
I'm not really sure. I'm not sure I understand the question. Is this a question about the Equality Act, which would amend all provisions of the Civil Rights Act?
While I'm waiting for her to respond, Shannon asks if it is dangerous that Sotomayor used trans language in the dissent, and that women, the category of woman, only got intermediate scrutiny.
So whether women as a category should have intermediate or strict scrutiny applied to claims of sex discrimination under the Equal Protection Clause is a very hotly debated matter within radical feminist circles. WDI USA holds the position that intermediate scrutiny is appropriate for claims of sex discrimination brought under the Equal Protection Clause. The Women's Liberation Front also has that position, but there are others who feel very strongly that strict scrutiny is the appropriate level of scrutiny for claims of sex discrimination brought under the Equal Protection Clause. Is it dangerous that Sotomayor used trans language? Sure, but so did the majority. You know, so did the majority and all of the concurrences. So, I mean, it's interesting because they all use language that obscure the material reality of sex. But as I mentioned, all of the opinions, including the dissent, sort of assume that sex is real and material. They just didn't say it outright. And they just didn't, they didn't give us what the Supreme Court of the UK gave women in the UK back in April, when they said the word sex, woman, and man are defined biologically. We didn't get that. But all of the justices sort of assume that sex is real. And even though they use language that obscures it, I was in a space hosted by Democrats for an Informed Approach to Gender, and Glenna Goldis made this important point, because this question came up. Her point was that those of us who spend a lot, or for some of us, all of our time in this space We understand that it is logically inconsistent to assume that sex is real while using language that obscures it. That's crystal clear to many of us. But for a Supreme Court justice, they don't even really fully understand what's going on here, which becomes clear throughout the opinions. They know that sex is real. They assume that, or many of them assume that the word transgender describes a coherent category of people. I think that to a certain extent, this is all because they are not as educated as many of us, and because they don't understand how, I mean, to use unprofessional language, they don't understand just how whack all of this has gotten. Because why would they? They're not spending all of their time on turf Twitter like I am.
Tina clarified that her question was about what happens to decisions based on the Civil Rights Act if the notion of protected groups is done away with.
I still am not sure I understand, but there definitely are some judges in the federal judiciary, if the entire concept of protected categories and the concept of these different levels of scrutiny goes out the window. There are plenty of judges who think that that entire analysis is wrong. But I mean, so I really wanted the court to say here that trans is not a protected category under the Equal Protection Clause, and they did not. But Justice Alito made an incredibly important point in his concurrence, which is to say the court can't avoid that question forever. And two really good cases in which to take up the question would be the sports cases, because there are two male athletes suing states that say you've got to have female-only sports. And that question is squarely before the court in both of those cases. And I hope the court takes up either or both of them and makes that clear, because the court missed the opportunity to make it clear here. I hope that answers.
An attendee whose name is S. England says someone has written a full academic article on the falsification of insurance codes, and she doesn't have the link to hand, but once you do, I would love to read that. So feel free to email that to us or to send it to WDI USA on social media. And your statement that trans is whack is quite popular. We could put it on a shirt. So I have a question for all of the panelists. We were all there on the ground in front of the Supreme Court on December 4th when they heard oral arguments in this case, and I just wondered if you all wanted to talk about what the mood was like there, what the crowd was like, both on our side and on the gender identity side. That's where I met Claire and Prisha for the first time.
Yeah, that's also where I met Claire for the first time, I think. And we've gotten to do quite a few events together and testifying and all of that since then. So that was really nice. As soon as you asked, though, I remember very starkly women shooting up testosterone in front of the Supreme Court steps. That was just wild. I mean, there's so many different types of harm that this cult perpetuates and feeds on, but drug using and drug glorifying and glamorizing and sharing behavior is one. Anabolic steroids are highly addictive. I mean, you can't find much information about testosterone being addictive if you're a female who's transitioning, but you can find a lot of support groups for men who need help, who've taken it and can't get off of it. And isn't that funny? I thought it was a really incredible day. The energy, I feel like we had, well, obviously we had better and nicer energy than the activists on the other side, but I think we had, our voices were heard and we weren't overpowered by their screaming and rambling. I remember it was really hard for me to raise my voice as much as I had to on the microphone to not be screamed over, but I think I was able to be heard and that things went well. And Claire, did a great job too. It was really nice to have her there. And I think it was her first event. So that was really nice. Shout out to her. And it was nice to see you too.
Yeah, the event outside the Supreme Court on December 4th was my first ever public event as a detransitioner. It was really a life-changing day for me. I met a lot of people that have really influenced my life in the past 6, 7 months, and it was it felt like a party to me. Like there was a really um powerful there's something really powerful about hearing everyone's voices just barely through the loudspeakers over everyone yelling, and like the music and people dancing, and um, all the banners, and just the energy in the crowd was so powerful. We all knew that we were there fighting an important and good fight. And there were people from all across every spectrum you could imagine. There were evangelical Christians and radical feminists, and it was it was a really powerful moment.
So I'll just tell a brief story as a way of addressing the diversity of thought issue of an interaction that I had that day, which is I saw a woman named Jennifer Chavez. And Jennifer used to serve on the board of Women's Liberation Front. And she and I worked together on countless friend of the court briefs that we filed in federal court. And then for personal reasons, she kind of had to step away from the movement. So she hasn't really been involved. She hasn't really seen it evolve. So we were chatting, and what happened on December 4th was in stark contrast to what happened during the oral arguments in the case that ultimately became Bostock. Those oral arguments were in 2019, I want to say October of 2019. And essentially, it was like five radical, and the rally outside the court during those arguments was hosted by Alliance Defending Freedom, which is a very conservative organization with whom Women's Liberation Front had worked before and got no end of criticism. Women's Liberation Front caught so much flack for working with conservative organizations such as ADF. But so we were there at that rally, we as Wolf, with ADF and many others, Concerned Women for America being one of them. But it was basically like five of us radical feminists and a bunch of diehard conservatives. Again, that's okay, but it just feels a little bit lonely to be someone on the political left, to be a lefty radical feminist, and there's like five of us and everyone else is conservative. So that happened in 2019. And then when I was chatting with Jennifer, she said the vibe has changed so much. And since I've been in this the whole time, I knew that. So it wasn't really remarkable to me at the 2024 rally. But Jennifer was blown away. She was like, I can't believe, who are all these Democrats for an informed approach to gender, Democrats against puberty blockers, LGBT Courage Coalition, which was holding signs saying stop transing gay kids. She was blown away by the diversity of thought and the diversity of political background of the crowd that was there that day. And I will just echo what Prisha and Claire both said, which is it had a great vibe. It had a great energy. Claire described it as a party. It was followed by, I think, some actual parties. So that was great as well. But it was a really great day.
It was very encouraging to be there. All right, I think we have our final question. Okay, I lied. We might have two more questions. All right. It is from Shannon. So it's back to the question of intermediate scrutiny. Why are women as a class under intermediate scrutiny? She wants to know if sex class violations don't rise to the level of religion or race.
Okay, so I could talk about this for a bajillion years, but essentially, back in 1971, there was a law on the books in the state of Idaho that explicitly preferred males over females in the administration of probate estates. Don't worry what a probate estate means. It doesn't matter. It was just an Idaho law that said we like men more than women, or, men should be preferred to be given this opportunity over women. And a woman challenged that, and it went up through the courts, and Justice Ruth Bader Ginsburg eventually got involved, and she argued, along with an ACLU attorney, before the Supreme Court, that women have the right to be protected under the Equal Protection Clause. So that was 1971, and she won. So we've been protected under the Equal Protection Clause since 1971. And there's been a body of case law that's been built up since that time that confirms that women and girls as a sex class are entitled to equal protection of the law. But the Supreme Court eventually evolved this concept of intermediate scrutiny. And what the Supreme Court basically said was that, yes, absolutely, women are entitled to equal protection as men, but the reality is that women and men are different in ways that sometimes matter. They don't always matter. And so, many laws that discriminate between the sexes, right? Not discriminate against anyone, but discriminate between the sexes. Some of those laws should actually be upheld. And so the court thought that it was not appropriate to subject them to strict scrutiny because distinguishing between women and men is sometimes appropriate in ways that discriminating between the races is completely inappropriate. And of course, this comes up all the time in these debates where people will say that those of us on our side of this debate are basically engaging in the same thing as Jim Crow racial segregation, which is absolutely ridiculous, racist, and insulting. So WDI USA thinks it's appropriate to maintain the intermediate scrutiny standard for claims of sex discrimination for all of those reasons. But again, that's not uncontroversial. There are a lot of feminists who think that strict scrutiny would better protect women and girls.
Alrighty. So, given that we're just past the hour, the $1 million question from Kay: how do we pique the progressive left so they recognize the harms of gender ideology? It seems like such an insurmountable task.
Yeah. I don't have a good answer for that. If I had a good answer for that, believe me, I would have done it several years ago. But, I mean, it's starting to work, and it's agonizing for many of us who have been doing this for a very long time. I've been trying to do exactly that for 10 years. And Carrie says we're getting there. Yeah, I mean, we know from post-election polling that this issue played a role in the election of Donald Trump. A lot of swing voters made their decisions at the last minute after seeing those Kamala Harris is for they, them, President Trump is for you ads. And we know from more recent polling in January that 67% of Democrats don't want men and boys in sports designed for women and girls. So we're kind of there. The problem, in my view, is the media. The problem, in my view, is that the media has been subjecting us, TERFs, to a media blackout for years now. They will platform conservatives, and I'm not complaining about that. That's a good thing. They will cite the briefs that are filed by conservative organizations in a lot of these cases. Again, that's a good thing. I'm happy that they do that. They will not cite our briefs. They will not interview us. I cannot tell you the number of hours I have spent writing op-eds and letters to the editor in the past 10 years, submitting them to the New York Times and the Washington Post, and they go completely ignored. I've gotten a few articles in recently. I got one in The Hill about a recent lobbying day that Wolf organized, in which a chief of staff for Senator John Fetterman essentially threw them out of his office after accusing a rape survivor of lying and comparing them to people who think aliens are real. So I've gotten a few articles published in a few important places, and that's good. But it's still just really hard, but we'll just keep going.
I do hope things will change with the media. I saw on Twitter today, it's a New York Times article, and I'm probably going to butcher the pronunciation of his last name, Nick Confessore, but he's writing about how essentially the quote-unquote transgender lobby overplayed their hand with Skrmetti. So I do hope this issue will be covered more thoroughly. All right, any final remarks from our panelists?
about the peaking the social left, I think that the trans community is doing a pretty good job of that on their own. But in closing, I want to thank everyone for being here. Thank you, Elizabeth, for having us, and thank you for the great questions in the chat. And it's been a good time.
Thank you so much.
Thanks.
Yeah. I'll just say, Aja made the point in chat that the 67% of support among Democrats doesn't matter if they don't speak out. And that's absolutely 100% right.
All right. Thank you so much to Kara, Claire, and Prisha for speaking. And thank you all for attending. Enjoy the rest of your afternoon. Bye.